So let's say your business has to pay out on a guarantee. It feels like a loss, right? You'd think you could just write that off on your taxes immediately. Well, a landmark Supreme Court case from 1967, the Plaridel Surety case, has a lot to say about that. And believe me, the answer isn't as simple as you'd think. This case really gets to the heart of a huge question. When is a loss really a loss in the eyes of the law?
All right, here's how we're going to tackle this. We'll start with the basics, the bond and the deal that went south. Then we'll look at the financial mess it created, how that turned into a tax dispute, and what the court had to figure out. Finally, we'll walk through the court's reasoning and get to the big final decision.
Okay, let's get right into the facts of the case. It all begins with a pretty standard business agreement, a performance bond. That, well, let's just say it set the stage for a major legal showdown. So check out this timeline. We start way back in 1950. Plaridel Surety issues this performance bond for a guy named Constancio San Jose. But then San Jose doesn't deliver the goods, in this case, logs. This triggers a lawsuit, and by 1952, a court says, yep, Plaridel and San Jose are both on the hook. But it doesn't end there. It takes another 5 years, all the way to 1957, for the Supreme Court to affirm that decision and for Plaridel to finally cut the check.
So you might be wondering, what exactly is a performance bond? Think of it like this. It's basically an insurance policy for a contract. Plaridel, the surety company, is telling PL Galang Machinery, hey, don't worry, if San Jose doesn't deliver those logs like you promised, we'll pay you for your losses. It's a guarantee to make sure the job gets done, one way or another.
All right, now let's talk about the money, because when that promise was broken, it had some serious financial consequences for Plaridel. And here's the final number. The original bond was for about 30,000 pesos, but after years of litigation with interest and fees piling up, the total amount Plaridel had to pay out in 1957 ballooned to 44,490 pesos. That's the check they had to write to Galang Machinery.
But here's a really critical piece of the puzzle. Plaridel didn't go into this blind. They had a safety net. Before they issued the bond, they had San Jose and another person, Ramon Cuervo, sign an indemnity agreement. This was backed up by actual collateral, mortgages. This is key because it means Plaridel had a clear legal path to get their money back from those two. So Plaridel pays the 44 grand. And what do they do next? They file their 1957 tax return and claim that entire amount as a business loss. It seems logical, right? But that single entry on their tax form, that's what kicked off the whole dispute with the Commissioner of Internal Revenue. And this really lays out the two sides of the argument. Plaridel says, we paid out over 44,000 pesos. That's a loss, so we're deducting it. Based on that, they figured they only owed 136 pesos in tax. But the Commissioner of Internal Revenue completely disagreed. They disallowed the deduction and sent Plaridel a bill for a deficiency tax of almost 9,000 pesos. So you can see the stakes were pretty high.
Naturally, this disagreement didn't just resolve itself. It went all the way up to the Supreme Court. And this brings us to the core issue of the case, the central legal question the court had to answer. And the question is this: can a company claim a deduction for a loss when it still has a legal right to be reimbursed by somebody else? I mean, Plaridel paid the money, it was gone from their bank account, but at the same time, they had those mortgages from San Jose and Cuervo. So had they really sustained a loss yet? That's what the court had to decide.
The whole case really boils down to a key phrase in the tax code. A loss has to be not compensated for by insurance or otherwise. Insurance is easy to understand, but what about or otherwise? The court needed to figure out if having a right to sue and collect from someone else, like Plaridel could with San Jose and Cuervo, counts as being compensated for otherwise. This interpretation was everything.
Okay, so now we get to the Supreme Court's reasoning, the ratio discendendi of the case. They didn't just give a simple yes or no. Instead, they laid out a logical path, a set of rules for determining when a loss is actually deductible.
And the very first thing the court said was, look, you can't just claim a loss at the first opportunity. The taxpayer, in this case Plaridel, has to exhaust his remedies first. You have to actually try to get your money back. A loss isn't truly sustained until you've done everything you reasonably can to recover it, and failed.
And when the court looked at what Plaridel did, or rather, what they didn't do, it was pretty clear they hadn't exhausted their remedies. They had that real estate mortgage from Ramon Cuervo, but they never tried to foreclose on it. They had a court judgment in their favor, but they never got a writ of execution to go after the assets of San Jose and Cuervo. And critically, they didn't offer any real proof that Cuervo was insolvent and couldn't pay anyway.
So the court basically established a clear two-step test for deducting a loss. First, the loss must be not compensated for by insurance or otherwise, meaning you've tried and failed to get your money back. And second, the loss must be charged off within the taxable year. You have to satisfy both conditions.
And that second step is a big one. To charge off a debt isn't just a state of mind. It's a specific accounting action. You have to formally remove that amount from your books as an asset and recognize it as a loss because you've decided it's uncollectible. The court looked for evidence of this charge-off, and there was none. Plaridel hadn't provided any proof they'd done this in 1957, so they failed on both counts.
So, putting all of this together, we can see how the court reached its final decision and established a really important doctrine.
This chart really says it all, doesn't it? This is the doctrine. To claim the deduction, Plaridel had to meet these requirements. Did they exhaust all their remedies for getting reimbursed? Nope, not proven. Did they establish that getting their money back was a long shot? Again, not proven. And did they formally charge off the loss on their books? Not a shred of evidence. They struck out on all three.
So the disposition was pretty straightforward. The Supreme Court affirmed the decision of the tax court. Plaridel's claim for a deduction was denied. End of story.
And this case leaves us with a really powerful takeaway. It teaches us that in the world of tax law, a loss is more than just a financial transaction. It's a conclusion. It's not just about the money going out. It's about proving, with evidence, that there's no reasonable hope of that money ever coming back in. It really makes you think, doesn't it? How certain does a loss have to be before it's well and truly lost?